My daughter was in town.
Have you been dating him initially?
I saw your message.
Just make sure when you go back, you do that. Get your pen. More importantly, to read through them first.
Good morning, everybody. My name is Judge Kathleen McHugh. I will be presiding over the magistrate hearings here this morning and this afternoon. I already have reviewed the probable cause affidavits. I'm going to make a probable cause determination in each of your cases and then set bond respectively. The first case I want to call is at Paul Ryan. Kamisha Douglas.
Paul Ryan, Your Honor.
That's not Kamisha.
That's not her.
That's foresight.
Douglas?
Douglas. Kamisha Douglas.
Page 11.
She there? She has a private attorney, Mr. Melnick.
She's on her way, Your Honor.
Okay.
Your Honor, they could cancel her. Tell her that we.
All right, we're going to go ahead and cancel Ms. Douglas. Her attorney, Mr. Melnick, is here.
And
She's got 3 no bond holds on her for 3 separate felony arrest warrants, which is going to be held no bond for each of those counts.
And Your Honor, the only thing I would ask is, and this is based strictly on the arrest warrant affidavit, is that the court make a finding today of proof evident or presumption great. I understand Mr. Melnick filed for an Arthur hearing. And
No, I didn't yet.
No, I'm saying you can.
Yes.
And we may have to satisfy that burden again at an evidentiary hearing. I'm just asking based solely on the contents of the arrest warrant affidavit.
Okay, Mr. Melnick?
No objection. Based on that, I can't contest what's on the warrant.
Okay, and I have reviewed the warrant. I do find the proof.
Thank you.
Great. This time to be held on each of these 3 arrest warrants, no bond.
Thank you very much, Your Honor.
Okay.
Take care.
Okay, take care.
All right, we're at main jail. Good morning, everybody. Can everybody hear me?
I'm sorry. Judge, actually, we can't hear you. I wonder if you could move the microphone around a little bit.
Can you hear me now?
Much better, thank you. Who are we looking for?
Can you hear me now?
Yes, ma'am.
All right, great. Good morning, everybody.
Morning, Judge.
Let's start with Shane
She's at Paul
Paul
Ryan,
Ryan,
Judge.
Your Honor.
Jane Forchar. Morning, ma'am.
Yes. Good morning.
You're here on a capias on a misdemeanor charge.
Yes,
Bond
ma'am.
has been set in the amount of $10,000. Your next court date is, well, it doesn't show a future court date. It's going to be determined, I would imagine shortly. You're going to go in front of the judge that issued this capias. But at this point, if you want to bond out, the bond has been set in the amount of $10,000.
Okay.
Okay?
Okay.
All right, back to the main jail. Tracy Nair.
Present at the main judge.
Okay? Okay, good morning.
Good morning, Your Honor.
Are you here? The charge is aggravated battery causing bodily harm. On a domestic violence charge, I do find probable cause to detain you. Does the defendant have any prior criminal history?
Zero.
2009 out of Miami-Dade, uttering a forged instrument, grand theft, identity theft, credit card fraud, unauthorized possession of a stolen driver's license. 2007, possession of counterfeit credit card, legal use of credit card, grand theft. That's out of Collier County. End of record.
So you have a recommendation as to bond.
Your Honor, I would be asking for, based on the level of alleged violence and prior record, I'd be asking $5,000 bond, no victim contact.
Judge, Ms. Nara is a 20-year resident of South Florida. She's been at the same address for the past 5 years. She has, she works at a place called Chef for Two. She has 2 children she takes care of, aged 10 and 2 years old. Strong family ties, no money in the bank or real estate. She does have a place to stay separate from the alleged victim should the court require it. and she's hoping that her family would bond her out. We were looking something in the neighborhood of $1,000.
Okay. All right, Mr. Linder, I didn't hear any violent priors, did I?
No, Judge.
Okay. I'm going to set her bond in the amount of $2,000. Not to have any direct or indirect contact with the listed victim in this case. If you're in the possession of any firearms or ammunition, they need to be surrendered to your local police department.
Jesse. Thank you, Judge.
Okay. Jesse and Yonta.
Judge, he's present at the main. He has declined the services of the public defender.
Good morning, sir. You're here this morning for a touch or strike battery, domestic violence. I do find probable cause. Does the defendant have any prior history?
Yes, Your Honor. In 2010, he was convicted of 2 counts of domestic violence battery against different alleged victims. In 2008, 2006, DUI, 2005, possession of cocaine. In 2003, he was arrested for battery that was dropped. Possession of cocaine, 2000, 1993, battery. Your Honor, based on his prior domestic violence convictions and the allegations in this case, the state would be requesting a $3,500 bond and no victim contact.
Judge,
He didn't want a lawyer. Okay. All right, sir. State Attorney's Office is recommending a $3,500 bond. You have a rather extensive violent history.
Do you own any houses or land?
Set bond in the amount of $3,500. No contact, direct or indirect, with the listed victim in the case. If you're in the possession of any firearms or ammunition, they need to be surrendered to your local police department.
Okay. Good luck. Daryl.
This way, sir. Down the middle.
Daryl Williams.
Present at the main, Judge.
Gary
Robertson. Mr. Williams, here on a habeas and misdemeanor charge. The bond has been set in the amount of $1,000.
Your Honor, because this was a capias from an unserved summons, I would just ask if the court would be inclined to issue a no victim contact order. This is the first time he's appearing before a judge.
Battery charge?
Yes.
I put 2 out.
Okay.
All right, sir, I'm also going to order that you not have any direct or indirect contact with the listed victim in this case.
And that is Shaquita Johnson, Your Honor. Could you give us the vote, please?
All right, not to have any direct or indirect contact with Shaquita Johnson. If you're in the possession of any firearms or ammunition, they should be surrendered to your local police department.
You charged with battery.
Judge, just brief argument on Mr. Ray. Didn't see anything in the 4 corners of the document that would indicate that he was served with the injunction.
You can go now.
Your Honor, this is
$1,000
actually
bond.
violating a no contact order from
Decline
a pending
PD.
battery case before you.
Okay, all right, Mr. Ray, you're here for 1 count of violation of an injunction for protection against domestic violence. Does the defendant have any priors?
Just checking to see if there's anything other than the case before you.
Hollywood.
This is,
Yeah, the pending batteries before you in this.
the battery charge came first?
Yes. Yeah, this is the violation of the no contact order from that
Okay.
case.
You own any property, bank accounts, automobiles,
Okay, let me check.
any money?
How old are you, Mr. Ray?
18 years old.
These knows individually, personally.
Your Honor, he has a pretty extensive juvenile history if you'd like to hear.
Valencia Weldon.
If we could if you could help, if we could go sidebar, Your Honor, that way we don't put his juvenile record over the
Okay,
internet.
all right.
Are you gonna pause? You're gonna call it? Or?
Hit this.
Oh. What's that? Well, Your Honor, since he declined the PD, just to cover our bases, I'd ask if you could inquire of Mr. Rye if he wants to hear me give you his record, or if he wants
All right,
to.
Mr. Rye, do you want the state attorney's office to tell me what your criminal history is without the benefit of having counsel?
Well, I'm sure he probably doesn't want to. The question is, does he
Can I
want
help the court and talk to him?
Sure.
Okay. You have. Judge, I'd be happy to assist the court and relay
Okay, thank you,
the.
sir. All right,
Okay.
What's that? Yeah.
want to go sidebar and tell me the priors?
Yes, please. We're just going to call over so
Okay.
counsel.
Here, you don't want one?
Mr. Sanchez?
Here, put in.
Judge, I think we need to finish with Mr. Ray.
You set a $5,000 bond.
I set it at 5,000 level 2 pretrial GPS.
What'd you say?
No contact with listed
5,000
victim.
level 2 GPS, no contact. Okay, and you did not revoke, is that
That's
correct?
correct.
Thank you,
If
Judge.
he gets out, he's going to be on an ankle monitor.
This is Mr. Sanchez, Judge.
All right, okay, Mr. Sanchez, you're here this morning for battery, second, or subsequent offense.
Do you have an attorney? Trust her, yeah. Were you arrested by your car? Do you have any vehicles? Do you own any cars or goods?
Oh, great.
Do you report the yes or the cash? And yes to the bank. Any children? You need to be precise with this, or they're going to take it back.
Got stuff.
It is zero
Most of
charge
them
and
are
harm.
in jail.
All needs except for needs.
It is zero charge done for you.
Okay. Okay, sir, you're here this morning for your magistrate hearing in regards to a battery, second, or subsequent offense. I do find probable
You did
cause
a
to
specific
detain you.
images
Does
for
the defendant
social
have any
security and
prior
employment.
Your Honor, out of New Jersey in 2003,
Property bank
he
account,
went through,
automobile, Market City.
it looks like a PTI program, but it looks like a diversion program for sexual assault. The charge was dropped. Please hold. 2007, he was convicted of assault in New Jersey. And in 2007, he was convicted of felony weapon possession He also had charges for aggravated assault dropped. I can also tell Your Honor, in 2007, a non-expiring injunction order of protection was issued against Mr. Sanchez, protecting the listed victim in this case.
All right, does the state have a recommendation?
Your Honor, because this is at least the second alleged act of violence against this victim, that another judge in another state has already ordered that shouldn't have contact with her. I know it isn't necessarily applicable in Florida at this point. And the level of violence alleged in this case, Your Honor, I'd be asking for a $7,000 bond.
Judge, Mr. Sanchez is he's a 2-year resident of South Florida. He's been living at his current address for about 3 months. He works at TGI Fridays. He's been there for about 1.5 years. He has 4 children, age 2, 8, 9, and 10. Strong family ties. He's got $50 in the bank. No real estate or land. He does have a place to stay separate and apart from the alleged victim while this is pending. And he's hoping that his sister will help to bond him out. We'd ask for a bond around $1,000, Judge.
All right, we're set on the amount of $7,500. No contact directly or indirectly with the listed victim. If you're in the possession of any firearms or ammunition, they need to be surrendered to your local police department.
Thank you, Judge. Okay, off you go. 75. 75. Steve?
Grantham Steve.
Present at the main.
All right, good morning, Mr. Steve. Here this morning for an aggravated battery offender knew or should have known the victim was pregnant. Does the defendant have any prior criminal history?
One minute, Your Honor. Showing a DUI property damage in 2011, and
Gonna finish up with Valley to Spring.
Are you on probation for anything? No.
seen arrest. Just seeing if it's still open. He had a resisting officer without violence from last year in Okeechobee County.
How old are your children?
He had an arrest for felony battery last year in Okeechobee County that was dropped. A trespass in 2011 in Okeechobee County. He had a 2012 out of Highlands County resisting an officer with violence and battery. He had a domestic violence battery 2012 in Glades County. And end of record. Based on his prior record and the allegations in this case, grabbing a woman that's 8 months pregnant, putting her in a bear hug and not letting her go, I'd be asking for a $10,000 bond and a pretrial GPS monitoring.
Judge, Mr. Steve is a 11-year resident of South Florida. He's been at the same address for the past year. He's currently unemployed. He does have 2 children, 1 on the way. Strong family ties, no money in the bank or real estate. He does have a place to stay separate from the alleged victim. Judge, he tends to self-bond. I would argue that the touching in this case is de minimis. There was no actual violence. A bear hug is not striking. And I would ask the court to consider pretrial release for this one.
We set on the amount of $5,000. No contact directly or indirectly with the listed victim. If you're in the possession of any firearms or ammunition, you need to be surrendered to your local police department.
Yes, ma'am. Thank you, Judge. Garcia. Judge, we have an argument. President at the main, we have an argument for count 2.
Garcia, you're here for 2 counts, joint battery, domestic violence, and also kidnapping.
And Your Honor, for the record, the arrest warrant affidavit states false imprisonment. And that is what the state is going to be seeking for the court to rule on today, not what's on the booking sheet.
All right, so the state agrees that there's no PC for kidnapping?
Yes, Your Honor, I'm just arguing that just that there's PC for false imprisonment.
All right. All right, I'll find, does the defense have anything to add in that regard?
Outside, sir.
That's kind of where we were going.
All right.
That's where we were going, Judge.
All right, so in the kidnapping charge, we're going to find no PC.
On the government, Social Security on the You get it from the government, Social Security on the
So.
Do you get assistance from the... No. Do you own any property, bank accounts, automobile, stocks, bonds, in New York City? Does that own your name?
Yeah.
You're worth how much can you get a
Five, PCS to false imprisonment only. Toucher strike battery, I do find probable cause. Does the defendant have any prior criminal history?
Your Honor, just one moment. Okay. Your Honor, he was arrested last year for aggravated battery, great bodily harm against the same alleged victim that was dropped. Just to inform the court, according to the probable cause affidavit, he allegedly striking her with, one moment, Your Honor. According to an independent witness observed the defendant put his hands on the victim's neck in an attempt to strangle her. This is also while she was 6 months pregnant, with a 1-year-old child present in the house when the incident took place. Your Honor, based on, and I understand they were dropped, but based on those allegations, with the allegations in this case here today, I do have concerns for this victim, the alleged victim's safety, Your Honor. I'm going to be asking for a $5,000 bond on one, $10,000 bond on two, with pretrial release of the GPS monitor.
Mr. Miller, anything?
Judge, Mr. Garcia has been living in South Florida his entire life. He currently works for American Hydraulics. He's been there for 3 years, but he's also recently enrolled at Sheridan Tech for a CDL program. He has 2 children, aged 2 months and 2 years. Strong family ties, no money or real estate. He does have a place to stay separate from the alleged victim. He's hoping that his family will help to bond him out. Judge, we would ask for something, I don't know, $1,000 per count.
Alright, as to the toucher strike battery, I'm going to set bond in the amount of $2,000, and as to the false imprisonment, I'm going to set that at $3,000. Level 2, retrial, GPS.
Okay. Thank you, Judge.
Have any direct or indirect contact with the listed victim? If you're in possession of any firearms or ammunition, they need to be surrendered to your local police department.
Thank you, Judge.
Thank you. LeGray Roberson.
Main jail, Judge.
All right, good morning, sir. You're here this morning for an aggravated assault with a deadly weapon without intent, domestic violence. I do find probable cause. Does the defendant have any prior criminal history?
Your Honor, he was just arrested early April of this year for battery that was dropped. 2013, he was arrested for aggravated assault, a deadly weapon that was dropped. 2011, resisting without violence and assault on a law enforcement officer. He pled those charges out. 2008, he had an aggravated battery. Based on the level of violence alleged in this case, threatening to stab his stepfather, Your Honor, I'd be asking for a $15,000 bond, no victim contact.
Okay. Mr. Miller, anything you want to add?
Judge, the only thing I could get out of Mr. Roberson is that he has a job.
It ties in with the community pretty much. I feed kids, homeless
you
kids.
feed kids?
The job ties in with the community. Feeds kids, homeless kids.
You feed homeless kids?
Pretty much.
How do you feed homeless kids?
It's a job that I work at. Refresh lives that helps feed the community.
Oh, okay. Kids. So he apparently helps feed homeless children in the community. Anything else?
That's it for the minute.
That's it.
All right. I'm going to send bond in the amount of $10,000. No contact directly or indirectly with the listed victim. If you're in possession of any firearms or ammunition or any knives, they need to be surrendered to your local police department.
Thank you, Judge. Okay. Do you want to sign him up?
Michael McGirt.
Present at the main judge. Monica, your name. This is McGirt.
For touch or strike battery, dating violence, and also second count possession of a weapon by a convicted felon. Does the defendant have any prior criminal history?
Yes, Your Honor. Misuse of 911, 2012. He was convicted of possession of marijuana with intent to sell or deliver, 2010. He was arrested in 2007 for violation of a domestic violence injunction that was dropped. 2000, possession of cocaine with a VOP, sentenced to a year and a day state prison. Purchase of marijuana, 94. Strong arm robbery, 93. Possession of cocaine, 93. Your Honor, based on the allegations in this case and his criminal record and the strength of the evidence, Your Honor, allegedly the officer witnessed the battery in this case, I'd be asking for a $2,500 bond on count 1 and a $2,500 bond on count 2.
Okay, Mr. Miller, anything you want to add?
Judge, Mr. McGirt is a lifetime resident of South Florida. He's been at the same address for the past year. He's currently receiving disability. He has 3 children, age 11, 12, and 16. Strong family ties. He does have some money in the bank, no real estate. He does have a place to stay separate from the alleged victim while this case is pending. And he's hoping that his family will help to bond him out.
Abajo por ahí porque yo salí del hospital también igual. Firma tu nombre.
And possession of a weapon by a convicted felon. We'll set that.
¿Usted está arrestado solo?
Contact directly or indirectly with the list of victims. Possession of any firearms or ammunition, they need to be surrendered to your local police department.
Yeah, that's 400.
Thank you, Judge.
Yeah. 4.
Francine Mezadou.
North Broward, Judge. North
Francine
Broward.
Mezadou. Good morning.
Good morning.
Here this morning on a case on a misdemeanor charge. Bond has been set in the amount of $149. Your next court date is June 11th at 2:30 p.m. Krista Durfee.
North Broward.
North Broward.
Okay. Krista Durfee, you're here this morning on a case of a traffic charge. Bond has been set in the amount of $500.
Will this case be automatically transferred to Central?
As long as she doesn't bond out. If she bonds out, it'll stay at South.
Monica Lowell.
Main jail, Judge.
Okay, all right. Good morning, you're here this morning on false ID given to a Leo and an out-of-county hold on a misdemeanor. There's also a petty theft, a second offense, which you're not being held on. I do find probable cause to detain you. False ID to a Leo, the bond has been set in the amount of 100, and the out-of-county hold on the misdemeanor charge, the bond has been set in the amount of 5,000.
Thank you, Judge.
Thank you.
Okay. So the bond is what? 5,000 to Miami-Dade for the Miami-Dade bond and $100 for the Broward bond.
Okay, Lisa Staley.
You have to make arrangements. If you want to make arrangements with the bondsman, you pay them whatever they want. $500 to a bondsman. Okay, good luck.
All right, Your Honor.
All right, good morning. You're here on 4 counts. Leaving the scene of a crime involving damage to property. Expired vehicle registration over 6 months. Driving while license suspended. First offense. And also driver presents non-current proof of insurance.
What?
Judge, may I just inquire if she can afford that bond? Can you afford a $100 bond, ma'am?
Yes.
Okay, then.
All right.
So at least on page 2, if she looks over, she probably will.
Lourdes Espinal.
North Broward, listen for your name. North Broward, Your Honor.
All right, got
Yep,
it.
come on.
You have cases coming up soon?
Yes, yes, Your
Your
Honor.
stuff? Okay. All right, Lourdes Espinal, you're here this morning for 3 counts. Count 1 is a petty theft, second degree. Count 2 is a capes on a misdemeanor, and count 3 is an out-of-county hold on a misdemeanor. Bond on count 1 is set in the amount of $25. On count 2 is set in the amount of $2,000. The out-of-county hold, the bond has been set in the amount of $10,000. I do find probable cause to detain you.
Judge, in the abundance of caution, would the court order a medical screen?
Where's that?
She's in a wheelchair. I don't know if she's getting
Okay.
served. So,
At the request of the public defender's office, I'll order a note.
Thank you, Judge.
All right, next case I have is Kelly Leanne Davila.
North Broward again, Your Honor.
All right, good morning, ma'am. I'm here this morning on a capes and a misdemeanor, loitering and soliciting an act of prostitution. Bond has been set in the amount of $100.
Judge, I believe this is a municipal ordinance case.
And this is which city?
It says Hollywood, Judge.
All right, and you're going to Fort Lauderdale, right?
Yes, Your Honor.
Okay.
Court reset it for. Will the court reset it for the afternoon? I believe Judge Hurley usually sets the municipal ordinances for the afternoon. Council may be present.
All right. You know Hollywood is usually here in the afternoon? They usually come in the afternoon? Hollywood? Okay. All right, we're going to reset this matter for the afternoon when your counsel can be present, okay?
All right.
I'll bring you back this afternoon, right back to the stuff.
Your bond, in the meantime, has been set in the amount of $100.
Okay, thank you.
Angela Moore.
North Broward.
All right, good morning, Ms. Moore. You're here on 4 matters: possession of PVP, burglary of unoccupied structure, escape, attempt to escape, and resisting an officer without violence.
Judge, I just believe that the issue with the carport, per the statute, they have to establish that it was done without the permission of the owner. I believe the issue is academic, but I would argue no PCS in the Berg structure.
All right, well, wouldn't a carport be the curtilage of a dwelling?
Right, but they have to establish that she didn't have permission to be there. And there's nothing in the 4 corners of the document that would establish that.
Your
All
Honor.
right, as far as the possession of PVP, I am going to find probable cause, and bond has been set in the amount of $1,000 in that count.
And Your Honor, I
What's the
would
state's
just
argument?
refer to the second page. While on scene, at the bottom, all on scene officers made contact with resident Ann Manadeo, who lives at 890 Southwest 42nd Avenue. Manadeo stated she did not give anyone permission to enter her carport by her vehicles.
Apologize, Judge, I missed that.
Okay, great.
All right, does the defendant have priors?
Your Honor, showing that she has. Seeing arrest in. Okay, looks like she had a DUI, operating while vehicle intoxicated, and a refusal out of Ohio from 2011. Looks like also in May 29th of this year, an individual obtained a order of protection injunction against her, and that is all, Your Honor.
Judge, may I just briefly inquire as to her ties to the community? Ma'am, prior to your incarceration, where were you residing? What city were you residing in?
Fort Lauderdale.
Is it a house or apartment?
A house.
Do you have family down here?
Yeah, my aunt.
Who's gonna help bond you out?
I'm not sure. I don't really have that, just my aunt, but she's struggling too.
Are you working?
Yeah.
Do you have money in the bank?
I'm sorry?
Do you have money in the bank?
No, I pay with my rent, no. Just I bartend.
Judge, will the court consider some form of pretrial release with a rehab component?
All right, as to the burglary structure and the escape. I'm going to release her to pretrial on those 2 counts, standard supervision. You have to post this on an $1,100 bond. And then I want her to have a substance abuse evaluation, follow any recommendations of that evaluation within 30 days of your release, when and if you're able to post bond. Well, I was just going to do pretrial on 2 and 3, but I need to do pretrial on all 4 then? Easier. Okay. All right, gotcha. It'll be pretrial, standard pretrial on all 4.
Right, but on 1 and 4, you have to put them on.
Correct. It's bond plus pretrial. And then substance abuse evaluation within 30 days of your release. Follow any recommendations of that evaluation. Also, random drug and alcohol screens. In fact, I want you to be drug tested a minimum of 1 time a week.
Okay, thank you. So pretrial, what's pretrial?
When you get out of, when you leave court, when you finally get released, I'm going to give you this sheet. You have to report to pretrial as soon as you're released.
So I'm getting released?
Whatever she said.
Judge, according to the docket, she's on loan.
She's on loan?
She's at the hospital.
Okay.
Good.
All right, so we reset this?
We reset it for tomorrow.
All right, let's reset this till tomorrow. Valencia Weldon.
President, the main judge, we have an argument.
Okay. All right, good morning. We're here for 2 counts of selling drugs, Schedule 1A, 1B, 1D, 2A, 2B, or 2C4. Bond has been previously set in the amount of $2,500 for each count. What are the probable cause arguments?
There are 2 arguments. There are 2 PC arguments, Judge. First of all, there's no evidence of sales involved in either of these items. And so I would argue that these are simple possessions, and I would ask the bonds to be adjusted accordingly. Secondly, it appears that none of the items were tested or confirmed to be anything in particular through the Centers for Disease Control. Therefore, there's no probable cause that this is propanolol or clomazepam. And so I would argue there's no PC to hold her. I'd ask that she be ROR'd on both counts.
Your Honor, I agree there's no PC at this time. I would ask for 24 hours to perfect.
Judge, in the meantime, could we get a reduction in this bond? Just based on the fact that there's...
Yes, she does, Your Honor.
I don't want to pretrial.
Hold on, right now.
And arrested before? Those are prior, sir. Married, single, still divorced.
Looks like she's out right now on a theft. Looks like she was arrested April 25th on a drug charge that has not, a filing decision has been made. 2010 felony battery, great bodily harm, theft 03, aggravated battery and retaliating against a victim or witness in 2002 with the VOP, possession of cocaine 99, grand theft 02, cocaine MDMA 02. She's also used aliases in the past as noted on her booking sheet. Your Honor, we would ask that the bonds be left as is until for the 24-hour period. Just 24 hours.
All right, I'm going to find no probable cause at this point, but we're going to reschedule this matter for tomorrow morning or afternoon?
Tomorrow morning's fine.
Thank you, Judge.
All right, I'm going to fill this form, no PC. Do I need to just check this off, no PC, and then come back tomorrow? Okay. All right, thank you.
Reset it.
Okay.
These are going back and back.
Sampatha Martinez.
North Broward, Dream.
Okay, good morning.
Good morning.
For petty theft, 2nd degree, 3rd or subsequent offense. I do find probable cause to detain you. Bond has been set in the amount of $750.
What about
Nicole Magnus.
Paul Ryan, Your Honor. That's it, she's done with it. It's not up to me. I'm not the judge.
All right, good morning. You've been charged with 3 counts. First count is petty theft. Count 2 is possession of cocaine. Count 3 is drug paraphernalia. If you find probable cause to detain you, bond has been set in the amount of $1,000 on count 2, the possession of cocaine. No charge attributed to the petty theft and the drug paraphernalia. Total bond amount is $1,000. Oh, for an OPC? Oh.
That's it, you're right behind her.
Trenda Diversi.
Yes,
North
ma'am.
Broward.
Okay, good morning.
Good morning.
You're here for 1 count of possession of cocaine. If you find probable cause to detain you, bond has been set in the amount of $1,000.
Yes, ma'am.
All right, come on, you're done.
Thank you.
You're welcome. Marie Cadet.
North Broward again, Your Honor.
All right, good morning, Mr. Cadet. You're here for 2 matters. 1 is a possession of cocaine. Count 2 is a violation of probation on a misdemeanor, for which you're being held in bond. I do find probable cause as to the first count. Bond has been set in the amount of $1,000. Your next court date will be June 11th at 11 a.m. for your violation of probation.
Okay, but I have a job that starts tomorrow. What happens to that?
Well, you're going to need to get your funds together to bond out. Well,
So,
that's true. We're going to go in front of the judge for your violation of probation. Hopefully you can resolve it.
No,
Next case, Cody Edwards.
Lindell.
Let's go, North Broward again. She's done.
So I have no
Come on, you have a no bond. You go to court in 6/11. Listen up, guys. You have to listen to what the judge says to you. It doesn't change.
You're here for 4 counts: possession of diazepam, possession of heroin, possession of PVP, and count 4, possession of drug paraphernalia. I do find probable cause to detain you. Bond for the first 3 counts is the amount of $1,000 each. Count 4 is bond is set in the amount of $100. Total of $3,100. Sure.
Can you afford that bond amount, ma'am? $3,100. Do you have somebody to bond you out?
Yes.
Okay.
Okay.
No, I don't. No, I don't.
And it also looks like she has limited ties. It's showing her address is in Washington State.
I believe Bond has previously said she doesn't have ties apparently to this area. She's in Washington State. All right, next case, Mona Gagan Saru.
North Broward. North Broward.
Good morning.
Good morning. You're here for a violation of community control on a possession of cocaine, and also case on a misdemeanor theft to deprive. You have a no bond hold on the first count and a $500 bond on the second count. Your next court date is June 10th at 8:30 a.m. for your violation of probation.
What day is that?
June 10th.
Okay, thank you.
Okay. Bartol Castillo.
Paul Ryan.
I guess if you have an attorney.
Bartol Castillo. Good morning.
For Ryan, Your Honor, he needs a Spanish interpreter.
All right, let's put this on recall for an interpreter. Max Alban.
Max Alban is president of Maine Judge. He has declined the services of the public defender.
All right.
He does not know who his attorney is. I was wondering if the state would be so kind as to look it up on Odyssey and perhaps give him his name and phone number.
All right, Mr. Alban, you're here this morning for a capias on a misdemeanor charge, and you have a no bond hold for that capias.
And, Your Honor, from what I can tell, this case is before Judge Zeller in drug court. There, I don't see any judge that filed the notice. I don't see any attorney filed the notice.
Any attorney of record at this point? Apparently, it's a drug court warrant.
Right.
Okay?
And we don't have a future date. Is that correct, Mr. Linder?
I don't see it.
No,
on my
but I know
paperwork.
Judge Zeller usually tries to get them in pretty quickly.
Yeah, should be sometime
Very good.
this
Thank
week.
you very much.
Okay.
Thanks for checking, Mr. Linder. Okay,
No problem.
we're good.
Jacob?
Jacob Mathis?
Mathis.
Jacob? You?
You have a
Out
municipal
the door.
city ordinance. Is this Fort Lauderdale?
Yes, it is, Your Honor.
Okay, your attorney is over there.
I don't know what that
Bond has
means.
been set in the amount of 25.
John Kilcrease. John,
Mr.
you're
Adrian,
next.
do you,
Judge, I wanted to, thank you, Your Honor. I wanted to advise Mr. Mathis to contact Mr. Sam Perlmutter, his public defender. If you'll just call the main number and check with your status of your felony. If the court's so inclined, I would ask the court if you would consider, if you wanted to resolve this, to withhold, possibly waive or court cost.
does he have,
It's got a,
well, the city,
this is just the city and they're not here. I don't know, Your Honor. Yeah.
hard to say, I can't make a decision on that.
Do you want to reset it then for the afternoon?
Let's go ahead and reset this matter for the afternoon.
Thank you, Your Honor.
The bond at this point is $25.
Could it be possible to cover the last case that I have?
All right, we'll see you after lunch.
All right.
That's fine.
Which one, what else? do you
Thank you, Your Honor. It's a bit back. It's on page 19. If that'll help, it's Gonzalo Pineda. Is at the main jail. We still no paperwork.
Mr. Atria, I think you missed one.
He's not on the docket, and I don't have any paperwork for him.
Okay.
Do you have anything else I can help
Mr.
you with?
Atria,
Mr.
on
Miller?
page 14, John Klaus.
I missed that one. I apologize for that. John Klaus. Yes, I did miss that, Judge. Page 14.
Come on.
I'll go home. It's like a 2014 municipal ordinance drinking alcohol in public.
I'm looking for his paperwork.
Thank you.
Mr. Frazier? You have an attorney? Who's your public defender? Okay. That's why I put the question. I gotta know what's going on.
I don't see that paperwork.
Should be close to the Jacob Mathis paperwork. 2 pages prior.
Do you have any children? They live with you?
All right, John Klaus. You're in a case on a misdemeanor charge.
Mr. Municipal ordinance, Your Honor.
And is this a Fort
What if
Lauderdale?
you together give
It is. Well, actually, Your Honor, I apologize. That shows Pompano. Yes, ma'am. Looks like Pompano Beach. That would not be Mr. McDonald.
Yeah, Pompano.
All right, okay, so this is Pompano. Bond has been set in the amount of $100. The next court date appears to be June 16th at 10 a.m.
Judge, I don't know if Pompano appoints counsel on, do you know if Pompano appoints counsel?
I do not. I do not. I'm sorry.
All right, sir, you can bond out.
But everything to do.
Come on up, bud.
Morning, sir. You're here for alcohol license suspended, first offense. I do find probable cause.
Yes.
Bond has been set in the amount of $100.
Date of birth.
Judge. Kyle. Jimmy Martinez.
Kyle McDougal.
North Broward, Judge.
North Broward, Your Honor.
All right, Mr. McDougal, you're here for 2 counts. One is a DUI alcohol or drugs first offense, and the second count is an unlawful speed posted. I do find probable cause to detain you. Bond has been set in the amount of $500. Yes, ma'am. He doesn't have any priors? Mr. McDougal, are you able to post this $500 bond, or do you want to be released to the supervision of pretrial without having to post a bond?
I would rather be released without posting bond. It'd be easier for my family that way.
Okay. All right, sir, do you understand all those conditions?
Yes.
All right. I'll release you to standard pretrial.
Thank you.
Jimmy Martinez.
Mr. Martinez is a Spanish language judge.
All right. You can't speak any English?
What can we
Need the interpreter then. We're waiting for an interpreter on the other one as well. How quickly do they usually come to court?
It all depends.
All right, let's put this on recall with the other interpreter case as well.
Thank you, Judge.
Freddie Corn.
Mr. Cornbliss, present at the main.
Okay, good morning, sir. You're here for a trespassing occupied structure or conveyance. I do find probable cause of detaining. Your bond is set in the amount of $100.
Judge, any chance of resolving this one?
What?
Withhold court costs?
State, does he have priors?
That open container he put out last year. Another trespass last year. No, I already put that out.
Benjamin Brown.
Uttering a false instrument and grand theft and obstruction 2013. And 2012, another trespass. The state's offered me a time served, but not a withhold.
Time served?
Yeah, I don't have a problem with time served, just not a withhold.
All right. So adjudication time served if he wants to resolve it. How long has he been in, a day?
He was arrested.
That's agreeable, Judge.
Okay. Sorry, does he want to resolve it?
Yes, ma'am.
All right, Mr. Cornwell, raise your right hand. Raise your right hand. Swear from tell the truth, the whole truth, nothing but the truth.
Yes, ma'am. Michael Herbert?
Say your name for the record.
Say your name for the record.
Freddie Richard Cornbliss.
All right,
Put your hand down.
You wish to plead no contest to this charge.
Yes, I plead no contest.
In exchange for that, I'll adjudicate you guilty, sentence you to time served, order you to pay court costs. Is that how you resolve it?
I'll take time served.
Okay, all right, time served.
Thank you, Judge. Okay, good luck. Michael? Coming? President at the main, Judge.
Mr. Herbert, you supporting the ordering of prowling charge? Bond has been set in the amount of $25. I do find probable cause to detain you.
Judge, I mean, I don't understand the outdated laws on
That's why I'm here.
and the old sentencing laws.
You can speak to an attorney and they can explain it to you. If you want to bond out, bond is set in the amount of $25.
And Your Honor, we just asked you to order him not
Hold
to
on a
return
second,
to the address in Parkland where this allegedly occurred.
All right, sir, no return to this Parkland address. Next case, Venerise Johnson.
Judge, I'm sorry.
Judge, I was going to make a PCR guy. I apologize. Judge, he didn't want to talk to the cop. The cop didn't observe the loitering and prowling. I believe there's case law that the cop has to make these observations. He was walking, I believe he was biking away from the property, and the cop ordered him to stop. He refused to talk to him. More, maybe a resist without violence.
Your Honor, the law as far as loitering and prowling is clear. The officer arrived on the scene, and upon arriving says the defendant trying to leave the scene on a bicycle upon his arrival. It's clear that if upon sight of police under the loitering and prowling statute, that it gives the officer reason to believe that there could be danger to the property or person, and it allows him to question. Having received this complaint, Your Honor, and then he wouldn't give any answer, so he was not able to dispel.
There's no opportunity to dispel because he won't talk to the police. So
But he was given an opportunity. That's
I'm
the
just saying,
yeah,
he
and I know.
to talk. Okay.
Yeah.
All right, so bond is set in the amount of 25. I do find probable cause.
All right. There you go. Good luck. Benoit, President of the Maine, declined PD.
All right, sir, you're here on a misdemeanor charge. It's a no bond hold. Your next doesn't show when the next court date is, though.
I think this is also. I'll check to see if this is also a. If you want me to check to see if this is also drug court.
All right. We're checking to see if this is a drug court case.
It is, Your Honor.
It is. It's a drug court case. You should be going in front. Is this Judge Zeller, I imagine?
Yes.
You should be going in front of Judge Zeller probably one day this week. Emmanuel Johnson.
Thank you, Judge. There you go. No bond hold. I'm staying. You're staying. You need to go down the middle? Thanks.
Right,
This is Mr. Johnson, Judge.
Here this morning on 3 misdemeanor charges for which there's been a case. First 2. And bond on those 2 cases is set at $250 for the first one, $250 for the second one, and ROR on the third. Next court date will be June 10th at 9 a.m.
All right. Good luck. Down the middle. At the door, Max.
Max Martinez.
Joey Britton. Joey. President of the Maine.
All right, Mr. Martinez, we're here for DUI with damage to property or person. Count 2, DUI, drugs first offense, and count 3, failure to use DUI care, failure to use due care. Stand 5 probable cause, bond is set in the amount of $1,000 on count 1, $500 on count 2, no applicable bond on count 3.
Thank you, Judge.
Does he doesn't have any prior medical trial?
Ortiz?
He has no record.
All right. Sir, do you wish to be released to the supervision of pretrial services?
1 moment, Judge.
In lieu of posting a bond.
I'm going to explain to him what it is, Judge.
Okay.
Yeah. He'll do pre-trial, Judge.
Okay. I'll release you to standard.
Okay, this is where you are. This is where you need to be. When you get out, just walk across the street. The entrance is here. They'll tell you what to do next. Good luck. Joey.
All right, sir. Drug and alcohol evaluation within 10 days of your release.
Sir, come back. I'll tell him, Judge.
All right,
This is Mr. Benton, Judge.
Joey Benton. You're here for 2 counts, loitering and prowling, and possession of cannabis. Bond on the possession of cannabis is an amount of $100. No charge on count 1. Probable cause.
North Broward, Your Honor, he's a medical reset.
All right, medical reset.
I'm sorry.
Where
are we? $100. Okay, there you go.
I don't.
Walk out. What happened? Spanish interpreter.
Joya. The last case was a reset. Mila Joya.
Okay. Yes. Spanish?
Español?
Camillo. Sí. No habla inglés. None at all, Judge.
All right, we'll put that on recall as well for the interpreter.
Thank you, Judge. Okay. Siéntate aquí, por favor.
Gerald Pina. Pena.
Speak English. President of the Maine, Judge.
Toucher strike battery. I do find probable cause. Bond is set in the amount of $1,000.
Your Honor, we just asked for an order of no victim contact.
No contact directly or indirectly with the listed victim.
Thank you, Judge.
Thank you.
Luis Guzman.
How you doing, Mr. Guzman?
Is there any way I can try to get a file for division?
We're going to find out in a second.
DUI, count 1, DUI with damage to property or person, count 2, and also count 3 is failure to use due care. Bond has been set in the amount of $500 on count 1, $1,000 on count 2, for a total bond amount of $1,500. I do find probable cause to detain you.
Judge, would you consider...
All right, Mr. Guzman, good news. Your wife is posting your bond as we speak.
There you go. Good luck.
All right, thank you.
Thank you, Judge. Marquis, President of the Maine.
Mr. Knowles, you're here for a caveus on a misdemeanor charge, a traffic criminal charge. Bond has been set in the amount of $500.
Can't resolve this. Judge, any chance of resolving this one? It's a no valid DL. It doesn't have
Let him
any.
go in front of the judge that issued the caveus.
Yes, ma'am. Good luck.
Mario Chinchilla. Mario Chinchilla. Going once. Going twice. Is he there? North Broward? Mario?
Hi, this is American. I just called it for
Mario?
He's here at Maine, Judge.
Sorry?
Chinchilla's here at the Maine, Judge.
Oh, he's in Maine. Okay. I was told North Broward. Okay. Property. Count 2 is operating without a valid DL. Count 3 is driving. Count 4 driver presenting non-current proof of insurance. Being held on 2, 3, and 4. Property of bond. Set in front of $2 on count 1. And I do find
Thank you, Judge. $100 bond. Good luck. Fly on, Frank. Fly on.
Dion Brown.
North Broward. Brown is in North Broward.
All right, Mr. Brown, you're here for, looks like the third count of aggravated battery caused bodily harm. I do find probable cause. Does the defendant have priors?
One moment, Your Honor. Patrice, could you do the priors on this one, please? Just see one moment, Your Honor. Yeah, can you tell place number he's held on?
Aggravated battery.
No. 1 and 2. Count 3. It's okay, she'll.
My most excellent deputy. The gods are smiling at me when they gave you Judy. And Debbie. We can do it? Oh, that's true. Might have to set those for the afternoon. We have a lot of the afternoon.
Yeah, you want to start with the most recent. Call the most recent. And don't worry about traffic stuff. Just, it looks like he's being held on that.
Oh, gotcha. 30-day rule violations, gotcha. Those are easy.
Taylor McGrath on behalf of the state, Your Honor. He has a 2015 battery he's being held on right now. He's got a 2015 he was adjudicated on for battery. He's got, a 2013 battery arrest, a 2012 adjudication for possession of cocaine, a 2009 possession of cocaine adjudication, a 2009 trespass adjudication, another 2009 possession of cocaine adjudication, a 2009 resisting adjudication, a 2008 criminal mischief adjudication, a 2002 possession of cocaine adjudication, a 2000 assault adjudication, a 2000 battery adjudication, a 2000 loitering adjudication, a 2000 resisting adjudication, a 2000 possession of cocaine adjudication, a 98 battery arrest, another 98 battery arrest while in custody on both of those, a 98 possession of cocaine adjudication, a 98 possession of cocaine adjudication, a 98 trespass adjudication, 1990 robbery 1 adjudication, 1990 aggravated assault adjudication, 1990 tampering adjudication, 1988 possession of cocaine adjudication.
All right, state have a recommendation for bond.
Judge, he's.
The state would be asking for 10,000, Your Honor.
Okay.
Judge, I would ask. He's being held $5,000 bond. He's being held $50,000 on count 1.
Which is a battery charge?
I believe for
$50,000?
$50,000 gap. So if he could have bonded out, he would have already bonded out, but he hasn't. So.
And I guess the argument is really picking up more violent offenses that should be considered mitigators.
Oh, but what I'm trying to say is like you're kicking a dead horse. I mean, that's what you're doing. We're piling on.
All right, I'm going to set bond in the amount of $5,000. No contact with the listed victim, direct or indirect. If you're in the possession of any firearms or ammunition, they need to be surrendered to your local police department. Levon Frazier.
It's got to be somewhere real quick.
Judge, I noticed the Spanish interpreter came in while you were talking. I thought he did.
Oh, okay. All right. Morning. Let's handle your cases. All right. Back on Camilo Pita Joya. Camila Pita Joya. Good morning, sir.
Buenos días, señor.
Buenos días.
Good morning. Está aquí para
A DUI,
por manejar bajo los efectos, primer delito,
and a DUI with damage to property.
y un manejar bajo los efectos con daños a la propiedad o personas.
I do find probable cause to detain.
Hay un motivo justificado para detenerlo.
Bond is set on the DUI at
Las
500,
fianzas son $500 por manejar bajo los efectos
and the property damage at 1,000.
y por el daño por la propiedad $1,000.
Total bond amount is
La
1,500.
fianza total son $1,500.
Judge, is he eligible for pretrial?
Madam pretrial? Yes.
Está elegible para el... No, él tuvo una agresión con agravantes. No descalifica para libertad antes del juicio.
Okay, Judge, can I ask the interpreter to ask my client why is he holding his hand that way?
¿Por qué está aguantando su mano de esa forma?
Porque me duele aquí todo.
Because I have pain all over here.
Could you ask him if he's seen a doctor?
¿Ha visto un doctor?
Sí, me pusieron ahorita, me hicieron unas placas y eso también.
Yes, they took some x-rays a little while ago.
Okay, thank you, Judge.
Okay, gracias, su señoría.
Okay.
¿Y tengo fianza o no tengo fianza?
Sí, fianza.
1,500 pesos.
Jimmy
Sí,
Alexander Martinez.
Good luck. Martinez, president of the Maine.
All right, sir, you're here this morning for trespass, occupied structure, or
Señor, está aquí para intrusión de una estructura ocupada o un carro. Hay un motivo justificado para detenerlo.
bond has been set in the amount of $100.
La fianza ha sido puesta a $100.
Judge, is this a case that is resolvable?
State, do you have a recommendation?
Tiene una recomendación, Estado.
¿Ella me escucha?
Actually, Your Honor, I'd be asking that this not be resolved.
Su señoría, pido que no resuelven esto. Esto es una tienda, es una casa de alguien. Y creo que esa persona tiene el chance de ser escuchada.
All right, sir, I'm not going to entertain a plea.
Ok, señor, no voy a ver una declaración. Si quiere salir, tiene la fianza de $1,100.
Thank you, Judge.
All right, thank you.
All right.
Mr. Castillo.
¿Fianza?
Oh, sí.
¿No puedo salir sin fianza?
No. Solamente.
Castillo.
Okay. Sí.
Buenos días.
Buenos días.
Tiene aquí 2 cargos de penal de tránsito, tiene 2 órdenes de arresto.
First bond,
La primera fianza es $500
second is also
y la
500.
segunda son $500
Amount of $1,000.
por un total de $1,000 de fianza.
Next court date is June 15th at
El 15 de
1:30
junio a la 1:30 p.m. su próxima fecha judicial.
Thank you.
Gracias.
Anybody else
Okay.
require the services of the Spanish interpreter?
¿Alguien más necesita el intérprete en
Not at the
español?
main jail, Judge. I did ask.
All right. Anybody else? Anywhere else?
¿Alguien más en cualquier otro lado que necesite el intérprete en español?
All right. Thank you, Madam
You're
Interpreter.
welcome. Have a good day.
Clavon Frazier. Main jail?
Who are we looking for, Judge?
Clavon Frazier?
Mr. Frazier is present at the main jail.
Mr. Frazier, you're being held for 2 probation violations or community control violations, felony charges, each of which carry
Benjamin.
a hold. Next court date is June 16th at 8:30 a.m.
There you go. Good luck. Brown. Richard.
Benjamin Brown.
Present at the main.
All right, good morning, Mr. Brown. You're here for possession of cocaine, drug paraphernalia, and driving while license suspended. Your bond on count 1 is set in the amount of $1,000. I do find probable cause to detain you.
Judge, is Mr. Brown eligible for pretrial?
There you go.
All right, does he understand that, Mr. Miller? Did you want to talk to him and see if he wants pre-trial with a drug evaluation and testing?
Yes, ma'am.
Does he want to do
That's
that?
acceptable.
He wants to do that.
Yes, he does.
All right.
Okay, you understand the random testing and the eval. So, drug evaluation, follow-up treatment, random testing. You understand?
Understand.
Off you go.
What is going on there?
One moment, Judge.
People like that, you know,
Richard Ortiz.
but then like that, it just means like a while ago at least.
Richard Ortiz, he's in main jail? Is that him? Oh, it's the last
Just
row.
the ground.
Richard Ortiz.
Oh, did she do him?
Sorry about that, Judge. Okay.
Good morning, Mr. Ortiz. You're here for petty theft first degree and 2 probation violations. Petty theft charges bond is a set amount of 100. I do find probable cause, and you're being held no bond on that 2 probation violations. Your next court date is June 10th at 8:45.
That's Wednesday. Good luck. Dennis?
Dennis Acosta Elias.
Yes. Yes, present at the main.
All right, sir, you're here on 4 counts: possession of methamphetamine, drug paraphernalia, driving on the wrong lane or side, and riding a bike without a light. I do find probable cause as to count 1. Bond has been set in the amount of $1,000. No charge is applicable, or no bond amount is applicable for the remaining counts.
Judge, Mr. Acosta, is he eligible for pretrial?
I saw no prior record that he called to verify his friend's name. He was posting his bond.
Your friend is posting your bond.
There you go. Good luck. Okay. You can get treatment on your own, though.
Okay, thank you.
Smith.
DeAndre Smith.
Is present at the main, Judge.
All right, good morning, Mr. Smith. You're here for several counts, 5 counts. First count is carrying a concealed firearm. Second count is possession with intent to sell, manufacture, deliver, PVP. Resisting without violence. Fourth count is trespassing. Fifth is a habeas on a misdemeanor. I do find probable cause to detain you. Bond has been set in the amount of $1,000 on count 1, $1,000 on count 2, $100 on count 3, and $25 on count 4. Bond on the misdemeanor habeas is $500.
Very good. Off you go. Good luck.
Because that's the action step. Mary, step over to the board. Deliver along with one of your friends.
Yeah, when you heard a violation of probation on a felony charge, being held no bond. Your next court date is June 10th.
I'm sorry?
At
That's what is next.
8:30.
Are you ready to keep owning your house?
Thank you, Judge.
Thank you.
Daniel, you're done. Daniel. Okay.
Daniel Deardoff. All right, Mr. Deardoff, you're here for sexual battery victim over the age 12 years or older, physical force, no damage. Does the defendant have priors?
Yes, Your Honor. He has a 2012 adjudication withheld on cocaine possession. He has a 2007 cocaine possession, another 1995 DUI, and a 1992 manufacturing or distribution of a controlled
What's the
substance.
state's recommendation?
The state be asking for a $15,000 bond, Your Honor, and a GPS monitoring level 1 pretrial.
Mr. Miller, anything you want to add?
Judge, Mr. Deardorff, 35-year resident of South Florida. He's been working and living at the same place for the past year and a half. He has no money in the bank or real estate. He's helping his friends will help the bond amount. I would ask the court to consider a much lower bond than that, and unless he's missed a substantial number of court dates, I would ask that the GPS pre-trial be waived. We don't.
All right. I'm going to set bond in the amount of $10,000. Level 2, pre-trial. Random drug and alcohol screens, a minimum of 1 time a week.
Thank you, Judge.
Thank you.
Okay. Good luck.
And also, I'm sorry, no contact, direct or indirect, with the listed victim.
Wait. She's saying to have no contact
No
with the alleged
contact,
victim.
direct or indirect, with the listed victim. And
Okay. Good luck.
That was it? I preempted you.
Okay. Lavorisburg,
Is that what you wanted to say?
He doesn't want to get interviewed?
Oh, he doesn't?
I don't know. What's that?
Oh, I'm sorry. I'll get him.
Lavorisburg.
My bad.
Good morning.
Yes, ma'am. Good morning.
You're here for, count 1 is enter exit, limited access on the interstate. Count 2 is unlawful speed. Count 3 is fleeing or eluding a Leo. 4 is tag unsecured.
Any property
No charges applicable for counts 1, 2, and 4. We need a hearing in regards to fleeing and eluding. Why do we need a hearing for that?
No, it just means that it's set.
Oh, well, why do they do that for fleeing and eluding?
I wasn't involved in the,
All right, okay. Okay, all right. Does he have priors?
Just a no priors, Your Honor.
Yes, no priors?
Bird.
Is Carl interested in this?
I don't know what page we're on, that's why.
All right. Does he want to be released to pretrial?
Judge, he declined the services of the public defender. It means you're going to hire a private attorney. Do you want to go to pretrial? Judge, I'll explain to him what
Please,
pretrial
I didn't know.
Pretrial release is supervision, where you have to check in,
Yeah.
okay, on a regular basis. You have to follow the rules. If you violate any of their rules, they'll sign a warrant, you'll get rearrested.
Yes, sir. I'll take pretrial.
Judge, he would like pretrial.
All right, I'm going to release him to standard pretrial.
Thank you, Judge. There you go.
Thank you.
This is where you are. That's where you need to go.
All right.
You just walk across the street. All right? Good luck. Storm Tillman. North Broward, Judge.
North Broward. Good morning, Mr. Tillman. You're here this morning for first count of petty theft, second degree, and count 2, possession of cannabis. The cannabis charge you're not being held on. Bond has been set in the amount of $750. I do find probable cause to detain you. Everton Edwards.
President, the main judge declined PD.
No, I did not. I already signed. I got one.
You just said you want to speak for yourself.
I know. Judge, Your Honor,
All right,
he's not telling the truth.
Good morning, Mr. Edwards. You're here for count 1's resisting or obstructing without violence. Count 2 is violation of probation on a felony. Count 3 is also a probation violation. Bond has been set in the amount of 100 on count 1. No bond on the remaining 2 counts. The next court date is June 10th at 9 a.m.
And ma'am, Your Honor, I signed papers for a public defender, but this guy, he's saying I declined, which is he's not telling the truth, so I don't know
All
how
right.
that's going to work
You
out.
have excellent counsel if you choose to be represented by the public defender.
Can you repeat that, ma'am?
I said you have excellent counsel if you choose to be represented by the public defender's office.
Okay, enjoy your day,
so I would
ma'am.
strongly encourage
And
you to
Judge,
use their services.
For the record, he came up here and said he wanted to talk for himself. So
Okay, all
I
right.
assume he didn't want our services.
For the record, I told him I was just messing with him for the record.
You don't mess around with people in here.
But I signed. I know y'all work together.
Barfield.
Bye-bye.
Barfield. President, the main judge.
Mr. Barfield, you're here on several matters. Count 1 is possession of cannabis. Count 2 is possession of cocaine. Count 3 is now a county hold on a felony. Count 4 is now a state hold on a felony. Count 5 is probation violation or community control violation. The last 3 counts, you're being held no bond. You're not being held on count 1, which is the possession of cannabis. And your bond on the possession of cocaine has been set in the amount of $1,000.
Thank you,
I do
Judge.
find probable cause to detain you.
Thank you. Judge. All right.
Jamel Daher.
President, the main judge.
All right, good morning, sir. You're here for a violation of community control on a felony. You're being held no bond. Your next court date is June 10th at 9 a.m.
Wednesday. Okay. White, Bertram. Bertram White.
Bertram White.
Bertram White. One moment, Judge. Yes, we got him, Judge.
He was next, sir. I just ordered. And I don't know who you are. You don't gotta wait until you get your name.
Possession.
Do you have an attorney? Are you gonna hire your own, or do you want a public defender?
Symbol 2 of a driver's license. Count 4 is possession.
Fake ID, Judge.
Sorry?
Fake ID.
Oh, I got you. Just never heard of it called that. All right, count 5, 6, and 7 are probation violations in which you have no bond. Bonds on 1, 2, and 3 are 1,000 each, or I'm sorry, 1, 2, 3, and 4 are 1,000 each. I do find probable cause to detain you. Next court date.
Thank you, Judge.
June 10th at 8:30.
That's Wednesday.
Am I here or back in Miami?
Here.
Okay.
That's from these two. I'll go have a seat over here so you finish.
I gotta finish you up.
Joe Williams, President the Maine. Danny Gonzalez.
You're here for a violation of community
Danny.
control on a felony. You're being held no bond. Your next court date is June 10th at 8:30.
That's Wednesday. Off you go.
Danny Gonzalez.
Danny. President the Maine.
All right, Mr. Gonzalez.
This is Mr. Gonzalez.
Grand theft auto, possession of cocaine, and the third count of drug paraphernalia. If you find probable cause to detain you, your bond is $1,000 on count 1, $1,000 on count 2, $100 on count 3.
Okay. 2,100. Off you go. Good luck.
Mr. Daly, on your possession of cannabis over 20 grams and resisting without violence, I do find probable cause to detain you. The bond on count one is set in the amount of
Larry Andrews. Come on, Larry. Okay, off you go. Judge, President of Maine, we have an argument.
It is a booking error. It's just supposed to be burglary of a dwelling. It's not supposed to be armed burglary.
Okay. All right, there's been a clerical error. He's not being charged with burg dwelling armed. It's just burg dwelling.
So he is bond eligible.
So he's bondable.
Yes.
All right, so I do find probable
That would be
cause. I do find probable cause to detain you. Does he have priors?
No, right now. He was
Judge,
arrested.
just to clarify, it's burg structure, not.
It's a structure.
I'm sorry?
It should be a structure. It's a school.
Should be a structure?
Yeah, it's not a dwelling. It was at Blanchard
What's
High
that
School.
dwelling structure?
Yeah, the statute covers all.
All right, so it's a structure. Okay, what's the recommendation?
He was
Or,
arrested.
I'm sorry, what are his priors?
He was arrested early April. I'm just checking to see for what. For possession of PvP, resisting without violence and tampering. Those charges are, violent decision has not been made yet. Patrice, do you have anything else? Yeah. Actually. Yeah.
State's recommendation.
Your Honor, I would be asking for a $5,000 bond and just no return to the school, obviously.
All right, I'm going to set bond in the amount of $2,000. No return to the school.
Thank you, Judge. All right, you're good. Off you go.
Can I ask her?
What do you want to ask her?
Judge,
Yes, sir.
would it be possible for me to be R&R?
To be what?
What's an ROR?
To be ROR?
No, sir. The state wanted $5,000 bond. I gave you a $2,000 bond. Make your best effort to post that bond. All right,
I have no
persons
plan.
over
Oh my.
65.
Thanks
This
again.
is,
I went.
All right, you find probable cause to detain him. Does the defendant have any priors?
Yes, Your Honor. He has an open pending currently DUI here in Broward County. He has a 2012 adjudication for resisting, a 2011 withhold on petty theft and disturbance at an educational institution, a 2011 withhold on exhibition of a weapon on school property, and that's it, Your Honor. The state would be asking for $7,500 given that he was out on his DUI when he picked up this new charge.
Mr. Miller, anything you want to say?
Judge, one moment. How long have you lived in South Florida?
I've been living here all my life. I'm 22 years old, and I've been living here since I was 1.
Where do you work?
I do side jobs. I do construction for a living.
How many kids you take care of?
I don't have no kids of my own, but
You
I
have family down
take care of one child.
Whose child?
My girlfriend's baby.
Okay. Do you have family down here?
I got my whole family here. I live with my dad.
Okay. And you have a job to go to when you get out?
Yes, sir.
You have to go to the bank?
I have no bank.
Okay. Who's going to help bond you out?
Nobody knows I'm here.
Okay.
If I could leave.
And Your Honor, the state would just also note for the record with the state's recommendation for bond that the alleged victim in this case is 80-year-old female.
I'm going to set bond in the amount of $10,000. No contact with the listed victim, directly or indirectly.
Yeah, let me see. I'm going to email to you.
Samuel Midas. there?
Coming, Judge.
Good morning. One count of possession of cocaine. I do find probable cause to detain you. Bond has been set in the amount of $1,000.
Thank you, Judge. Okay, off you go. Good luck.
Luisa? Augusti. Oh, he bonded out.
You just
I
write on the
need to sign
bottom,
this if he
bond
bonded?
posted.
Right, bonded.
Win, Azevedo, win.
That's all.
Page 24.
Manuel Rodriguez Valcarsol.
Judge, he's at the hospital.
He's in the hospital?
Medical reset, Judge. Thank you.
Behind the phone.
And
Azevedo.
North Broward.
All right, sir, you're here for count 1, driving while license suspended, third or subsequent offense, and also temporary tag expired 7 days or less. You find probable cause to detain you. Bond has been set in the amount of $750. Frank Mussolino.
Yes, ma'am.
North Broward.
I'm sorry? Yeah?
The court inclined to release it just for result control. I don't know what his driving history looks like. Or he's failed to I have to actually see.
State. Let's go back to Mr. Acevedo.
Sorry, Broward. I got an email that he was
No, that.
verifying.
I'm done.
No.
Should I?
Acevedo. Let me ask the
North
state.
Broward.
Does he have prior state?
Checking that right now, Judge.
Can I ask if he can afford a $750? He can't.
That I don't really care as much about that. I just want to see. Except that it should appear on there. Your Honor, state has no objection if the court is inclined to release him to
All right,
pretrial.
Mr. Acevedo, do you want to be released to the supervision of pretrial?
Yes.
You're going to have to comply with all their terms and conditions. No driving without a valid driver's license would be one of them. You have to report to them. And
Yes.
complete whatever terms and conditions they require of you. Is that what you want to do?
Yes, Your
Without
Honor.
having to post a bond. All right, if you don't comply with their conditions, they're going to send a warrant to your judge and you're going to go back into custody. Do you understand that?
I do.
All right, you'll be released to pretrial.
Thank you.
Frank Mussolino.
North Broward.
All right, Mr. Mussolino, you're here on several matters, 6 matters. Number 1 is a disorderly conduct, breach of the peace. Count 2, loitering and prowling. Count 3, failure to notify HSMV of your change of address. Count 4 is failure to change your address on your DL. Count 5 is driving in a vehicle with unsafe or defective equipment. And count 6 is a probation violation or a community control violation. Your bond on the first count is set in the amount of $25. No charge for counts 2, 3, 4, and 5. However, you're being held no bond on the violation of community control. And your next court date is June 10th at 8:30. I do find probable cause to detain you.
But may I say something, Your Honor, please? May I say something,
Yes, sir, go
please?
ahead.
I didn't violate my community service.
All right, you need to tell that to the judge and to your attorney.
I have an 87-year-old father that has dementia, and I run a business in Oakland Park, ma'am. I'm a very responsible person.
Okay, will you be able to tell the judge what the situation is on June 10th?
Thank you, Your Honor.
Next case is Linford Moody.
He's present at the main, Judge. You may recall this morning I dropped off some paperwork on this case.
Right, I remember.
So I think what happened was it was unclear that there was a not in custody information in this case, and so they did not give him a bond over the weekend. They reset it so they'd give us an opportunity to review the record, and I did find the capias, and it was a not in custody information. He didn't miss any court dates, just the information was issued with him not in custody.
All right.
So he is entitled to a bond on count 1.
State, would you agree it's not because of a failure to appear?
Yeah, no, it would appear to be a
All right.
custody.
All right. Does he have priors?
1 moment, Your Honor.
I do find probable cause to detain him on counts 1 and 2.
Chief, do you have notes as far as priors from over the weekend?
So Mr. Moody has been living in South Florida for about 25 years. He's been working, lived at the same address for the past 5 years, so he has a stable home. He's been working at East Coastal Masonry for 4 years. He's a mason. He does have 1 3-year-old child that he takes care of. No money in the bank, no real estate. He's going to ask his friends to help bond him out. Was wondering if the court would consider pretrial for him.
State, does he have priors?
Patrice, I'm sorry. Your Honor, we would be opposing straight release to pretrial on a case where allegedly broke into someone's home.
Well, it is a 2-year-old case, Judge, so take that into consideration, please.
He's got a $1,000 bond on count 2, which is the grand theft. I'm going to set bond on count 1 in the amount of $2,000.
Thank you, Judge.
$3,000.
All right, $3,000. Good luck to you.
All right.
How much?
So that concludes the
300. Mr. Dixon.
Tyrone Dixon.
Your Honor.
Your dwelling structure or conveyance armed?
Yes, Your Honor.
You done?
How's there a $5,000 bond on that?
Judge decided to set a $5,000 bond, Your Honor. We found no PC at the time and gave a bond rather than waiting for the 24 hours. Your Honor, I provided a supplemental report.
You did already?
At this time, I'm not going to be seeking proof evident presumption grade based on the allegations, Your Honor. That one person screamed, he has a knife, and she saw a shiny object. I'm not certain that would satisfy proof evident or presumption grade. That being said, Your Honor, I would ask the court to reconsider the bond because Judge Mark set a $5,000 bond without having this supplemental report. So I think since more facts are being alleged, the court is in a position where the court can adjust the bond if you deem it appropriate.
All right.
No.
Mr. Does the PD's office have anything to add?
Judge, I would say this is not a situation. She knew who he was. It was also in the probable cause affidavit. It indicates that she's homeless and she does feed him. So it's not a random situation. Don't see anything aggravating unless it's taken get into his priors. But I don't think there's any aggravating factors that would require the bond to be raised from $5,000.
All right. Does he have prior state?
Your Honor, he does 2008 aggravated assault with a firearm and carrying concealed firearm, attempted tampering with evidence, he violated probation and was sentenced to 18 months. Your Honor, I believe what makes it now aggravating is the initial report says there was a threat to kill. But now, Your Honor, now I think it's even more concerning that there was a threat to kill, considering he had some type of shiny object on him. Someone yelled he's got a knife. Now, I understand that there's not enough to satisfy proof evidence at this point, but I am concerned whether she knows, and I can tell you, I can also proffer, because I spoke to the detective who spoke with the family, they're concerned with him out in custody because they believe he's going to continue to use Flocka, and they're concerned about their safety if he's on the street using Flocka, and his own safety to harming himself by using this. So, Your Honor, certainly the court can consider raising the bond. The court can consider a GPS monitor based on the additional facts. It's in the court's discretion. I do think that there is more for the court to consider than there was on Saturday.
Judge, I would like to reiterate my argument that there's nothing aggravating from these. Just because somebody yelled knife doesn't, and there was no knife located based on the four corners of the document, I don't think there's anything aggravating in here that would justify raising the bond from $5,000.
I am concerned about the Flocka, so the allegation of that.
And Your Honor, I would also note, the victim, who knows him, was concerned enough that she says he immediately backed off and ran across the street to notify BSO. So she, obviously knowing him, felt enough concern that she felt she had to remove herself from the home.
All right. If he's able to post this $6,000 bond, I'm going to put him on standard pretrial. He needs to have a BARC evaluation within 15 days of his release.
Yeah, well, you can't do that, BARC, can you do it somewhere else?
BARC evaluation and or a substance abuse evaluation within 15 days.
Judge, is this
Recommendations of that, and I also want him to be random drug tested a minimum of 1 time a week.
Judge, is this in addition to or in lieu of the bond?
This is in addition to.
Okay.
He's able to post this bond, $6,000 bond total, standard pre-trial with BARC and or substance abuse evaluation in 15 days, random drug testing a minimum of 1 time a week.
And Your Honor, and I just in abundance of caution, because I wasn't here on Saturday, I just asked if Your Honor could order no return to this residence and no contact with any of the residents of the residence on 8th Avenue in Pompano Beach.
Okay. No return to that residence and no contact with any of the witnesses involved in this case or any of the residents involved in any of these charges.
Thank you, Judge.
And this is Mr. Mormon.
Good morning, Your Honor.
Good morning. You're here for a counter burglary with an assault or a battery. Bond has been set in the amount of $5,000. Is this a...
Your Honor, this is a perfection. I've been informed
2011, 2013, I served in northern Afghanistan.
Why there was no PC found, but apparently there wasn't.
Just the reason that no PC was found was because the intent aspect of the burglary wasn't satisfied. So I believe the judge, based on that, just the fact that they were in the carport, in of itself doesn't satisfy the burglary. So there was no PC found by the judge because of those reasons.
Then I would make a legal argument, Your Honor, which I don't need to provide new facts for. The intent, if a battery is committed therein, then the intent, then that's the intent to commit the crime therein, is the battery.
But bond was set in the amount of $5,000. So...
Oh yeah, no, this is just a question of, at this point, of PC or no PC. And all I'm saying is if no PC was found strictly on that there was an intent to commit a crime, my legal argument, which I believe I'm allowed to present without, if it's strictly on legal grounds, then I don't need to present new facts, is that intent can be formed once entry is made. It doesn't necessarily have to be formed prior to. And if someone commits a battery after lawful entry, then there is the intent to commit the crime therein.
Can I chime in?
Yes, sir.
Judge, I don't believe, without additional information, that the judge is that this court is in a position to second guess the previous court, and so I would ask the court to leave the status quo and allow this man to bond out.
Leave it at $5,000. Does he have any priors?
No, Judge,
well,
he's
here's here's the problem. The court set it a $5,000 bond for found no PC.
Right.
That being said, my understanding of the law that Mr. Miller is referring to is when the issue is factual in nature.
Right.
If, like, let's say, the court finds on a drug case no probable cause because it's not field tested. I can't just come in and say, well, Your Honor, I was told it was field tested. I have to present facts.
Right.
But if my issue is that it's strictly legal, then I wouldn't have, there's no new facts to present if the issue is a legal one, and not a factual one.
Well, I'll tell you, I'm not going to leave it status quo. Bond is set in the amount of $5,000.
Judge, Mr. Mormon is a veteran of the United States Army, served in Iraq in 2011 and 2013. He has no priors ever anywhere. And we're wondering if the court would consider pretrial release for him.
It appears he has no ties, Your Honor. I'm showing that he's from Ohio.
All right. Mr. Linder indicates he's from Ohio.
Yes. I think he's down here in rehab.
And then found with heroin, so
right,
there's
okay.
a concern there.
I'm going to leave bond as set in the amount of $5,000.
Thank you, Judge.
All right. Is that everything?
Yes. Do you understand the argument?
On what order?
For the public defender's
sure,
office.
sure.
If it's a factual issue.
All right, that's everything, right? All right, we'll see you here at, what time we start in the afternoon?
1:30.
1:30.
But if it's strictly legal, I can have all the facts.
Is this a
It's not
record
gonna
to be
change
done
the
at
law.
10:15? 10:20?
No, but it's
Really?
it's not a competition. It's just a great start to the week.
What did Eric say? Today?
You don't gotta look at it as, who's fast. This is.
Oh, here.
Oh,